District Regulation Attendance Enforcement R 5113. Attendance enforcement is a shared responsibility between the Clark County School District and the student's parent or legal guardian. The parent, legal guardian, or other person in the state of Nevada having control or charge of any student is required to send the student to school during all times that the public school is in session, NRS 392.040. The Clark County School District requires that students enrolled for school in the Clark County School District attend school regularly in accordance with the Nevada revised statutes. Each student is expected to attend school for the entire school day. Student tardiness. Student tardiness is a serious disruption to the educational process. Tardiness interferes with time to teach and infringes on the educational rights of other students. Each school shall develop and implement a well-communicated tardy procedure. Elementary. A student is to be marked tardy who is not physically present in the classroom at the start of the instructional day. Secondary. A student enrolled in grades 6 through 12 in a secondary school who is not physically present in the classroom at the start of the instructional period but reports to the classroom after that time is to be marked tardy. If the student misses more than 30 minutes of the instructional period, the student has missed an essential part of the learning experience. Therefore, for purposes of attendance enforcement, a secondary student who is more than 30 minutes late to any class period shall be counted absent from that class, and the teacher shall record the absence accordingly. 2. Recording daily attendance. The Clark County School District is responsible for maintaining an accurate attendance record for each student enrolled. R 5513, page 2. Elementary and elementary students shall be recorded as absent for half of the day if more than 1 hour and 55 minutes of the instructional day are missed, and recorded as absent for the entire day if more than 3 hours and 45 minutes of the instructional day are missed. Secondary. 1. A secondary student shall be marked absent for the entire day if the student is absent every class period. 2. A secondary student who is absent less than a full day shall be marked absent only in those classes from which the student was absent. 3. A secondary student who is more than 30 minutes late to class shall be marked absent for that class period only. 3. Limitation of absences. Regular student attendance is critical to the student completing coursework required for earning credit and/or being promoted to the next grade. Both in-school and out-of-school learning activities and assignments contribute to a student's ability not only to attain a passing grade in a course, but also to master the standards for each course of study. Elementary. Excessive absenteeism, retention. 1. The Clark County School District expects that schools must attain a standard of 90% attendance. Individual student absences should be limited to a maximum of 20 total absences per school year. Elementary students who exceed 20 unapproved absences during the school year may be retained in the current grade. 2. For the purpose of this subsection, all arranged absences in excess of 10 during a school year shall be considered unapproved. All arranged absences for which the make-up work was not completed and submitted as specified by the teacher shall be considered unapproved. R 5113, page 3. Secondary. Excessive absenteeism, denial of credit, retention. 1. The Clark County School District expects that schools must attain a standard of 90% attendance. Individual student absences should be limited to a maximum of 10 total absences per semester. Drivers under the age of 18 are now required to show proof of school attendance per NRS 483.2521. All Nevada students will be required to submit a DMV 301, the Department of Motor Vehicles Certificate of Attendance form, to the local DMV office when applying for either an instruction permit or driver's license. Students who fail to meet the attendance standard outlined above will be unable to secure the school official's signature required on the DMV 301 to apply for an instruction permit or driver's license. 2. A student's medical illnesses or conditions may prevent a student from meeting the above goal, and absences which are due to the student's physical or mental inability to attend school, if properly documented and submitted to the school within the timelines defined by this regulation, will not be included in the determination of a student's denial of credit or retention if the student has completed coursework requirements. 3. For the purpose of this subsection, all arranged absences in excess of 10 during a school year shall be considered unapproved. All arranged absences for which the make-up work was not completed and submitted as specified by the teacher shall be considered unapproved. 4. The limitation of absences may be adjusted for schools using block or unique schedules, which should be equal to the total number of absences allowed for schools not on a unique or block schedule. C. Are required parent conferences to be scheduled by the principal or designee when the following occurs due to excessive absenteeism. 1. A student has been identified for possible retention. 2. A student may be denied course credit. 3. A student is being recommended for enrollment at an alternative school. R 5113, page 4. 4. A student is deemed to be a habitual truant, and/or 5. A referral for educational neglect is contemplated. Elementary. 6. Administrative sanctions are pending per NRS 392.148. Schools may investigate, in cooperation with the parent and student, the cause of absences, and the principal or designee may determine a course of action to address excessive absenteeism. IV. Absence documentation explanation. Readmittance to class. Each school will include specific directions and/or procedures relative to the manner in which students will be readmitted to class subsequent to an absence in the student-parent handbook or other written communication to the parent guardian. For purposes of consistency, schools may require parental guardian confirmation of the reason for the absence in writing prior to or upon return from each absence. Verified medical appointments, medical excuses, medical documentation and/or other explanations must be presented in writing by the student from the parent guardian or personally by the parent guardian within 3 days directly following the absence. Via classification of absences. The determination of the proper classification of an absence requires the exercise of judgment on the part of the teacher, principal, or designee. To evaluate the proper classification of the absence, the school may reasonably inquire, investigate, and/or request further documentation from the parent guardian. Absences from class or school due to a student's participation in a school-sanctioned activity, or absences from class or school resulting from a student's suspension or required parent conference shall not be counted as absences for the purpose of attendance enforcement. A. Approved absences. Explanations by the parent, legal guardian, or physician stating the reason the student was absent within the meaning of sections 1-4 as listed below must be presented to the teacher or principal designee not later than 3 days after the student returns to school. Absences shall be approved for the purposes of attendance enforcement within the meaning of the Nevada Revised Statutes when R 5113, page 5. 1. The student is physically or mentally unable to attend school, or the absence is related to the student's disability and the coursework has been completed. 2. The approval of the teacher, principal, or designee has been given for an unavoidable absence due to an emergency. 3. The student is absent due to a required court appearance or religious holiday. 4. The absence has been arranged pursuant to the request of a parent or legal guardian prior to the absence and does not exceed the allowable 10 arranged days per school year. B. Unapproved absences within the meaning of the Nevada Revised Statutes. An absence is unapproved when 1. The arranged absence was not requested in writing in advance of the absence or exceeded the allowable 10 arranged days per school year. 2. The absence was not due to the physical or mental inability of the student to attend school, the student's disability, an emergency, a required court appearance, or religious holiday. 3. The absence from class or school was without written permission from the teacher, principal, or designee. 4. The parent, guardian, or person in charge of the student failed to notify the school of the reason the student was physically or mentally unable to attend, or the nature of the emergency, court appearance, or religious holiday within 3 days after the student returned to school. 5. The student failed or refused to attend school when so directed by the parent or legal guardian or school official, or 6. The parent or legal guardian or person having charge of the student failed or refused to require the student's attendance at school. R 5113, page 6, see truancy. 1. An unapproved absence for one or more class periods, or the equivalent of one or more class periods during the school day, shall be deemed a truancy, NRS 392.130, 2. If a student has been declared truant 3 times for unapproved absences, the principal of the school, or designee, shall report the student to a school police officer or the local law enforcement agency for investigation of habitual truancy and issuance of a citation, if warranted, in accordance with NRS 392.149, NRS 392.144. 3. The Nevada revised statutes do not distinguish between truancy resulting from inaction of the student and that of the parent or legal guardian. 4. Any child who has once been declared a habitual truant and who in an immediately succeeding year is absent from school without a valid excuse may again be declared a habitual truant. 5. Once a student is identified as a habitual truant in accordance with NRS 392.144, the school shall conduct an investigation, set a hearing date, and provide a written notice of the hearing to the parent or legal guardian of the student. If the student remains a habitual truant following the investigation and hearing, the school may issue an order imposing administrative sanctions. Administrative sanctions include the suspension of the driver's license of the habitual truant student for 30 days for the first offense. If the student does not possess a driver's license, the order must provide that the student is prohibited from applying for a driver's license for 30 days. The second offense and any subsequent offenses will result in the suspension of the driver's license of the habitual truant student for 60 days. If the student does not possess a driver's license, the order must provide that the student is prohibited from applying for a driver's license for 60 days. VI. Notification of absence. Notifications of student absences will be made to the parent, legal guardian, or other person having control or charge of the child as recorded in the student information system upon each unverified absence. In the event of an unapproved absence, the teacher, attendance officer, or other school official shall deliver or cause to be delivered a written notice of truancy to the parent, legal guardian, or other person having control or charge of the child, NRS 392.130, VII. Make-up work. Teachers shall provide an opportunity for a student to make up missed work due to any absence, and students shall be held accountable for the work. When the student is absent, however, the educational experience is lost during that absence might be irretrievable because the instruction and interaction in the instructional setting cannot be duplicated through make-up work. Elementary. After any absence, the parent or legal guardian of an elementary student is responsible to contact the teacher to obtain appropriate make-up work within 3 school days directly following the absence. Once contact has been made with the teacher, the nature of the make-up work and the time allowed for completion will be determined and communicated by the teacher to the student parent or legal guardian. Students shall be allowed a minimum of 3 days to complete make-up work. B. Secondary. After any absence, a secondary student is required to initiate contact with the teacher to obtain appropriate make-up work within 3 school days immediately following the absence. Once contact has been made with the teacher, specific make-up work must be completed and returned to the teacher, within a reasonable length of time, to be determined by the teacher and communicated to the student parent or legal guardian. The make-up work must be returned to the teacher, by the specified due date if it is to be acknowledged. Students shall be allowed a minimum of 3 days to complete makeup work. VIII. Alternative Program Referral Denial of Credit Retention Administrative Sanctions R 5113, page 7. R 5113, page 8a. B. Prior to the referral to an alternative program, denial of credit, and order imposing administrative sanctions, or retention in the current grade, a written notice of the attendance record shall be sent to the parent, legal guardian, and/or the student. The written notice must include the procedure for requesting a review of absences under due process. Referral to an alternative program may be initiated for any student who has been denied credit due to excessive absenteeism. Written notice of options available for making up deficient credits shall be provided to the student and parent. IX. Due process elementary before a student is denied promotion to the next higher grade for failure to comply within the attendance requirements prescribed. The principal shall provide written notice of the intended denial to the parent guardian of the student. The notice must include a statement indicating that the student and parent guardian may request a review of the absences of the student and a statement of the procedure for requesting such review. Upon the request for review by the parent guardian, the principal or designee shall review the reason for each absence of the student upon which the intended denial of promotion is based. After the review, the principal or designee shall credit towards the required days of attendance each day of absence for which 1. There is evidence submitted by the parent guardian that the student has physically or mentally been unable to attend school on the day of the absence, and 2. The pupil has completed coursework requirements. If the parent guardian disagrees with the decision of the principal or designee that the standard under NRS 392.1223 and B has not been met, the parent may appeal to the assistant superintendent or designee. The decision of the assistant superintendent or designee shall be final. B secondary after receipt of notification of the impending denial of credit, and order imposing administrative sanctions or retention in the current grade, the parent guardian or student may request a hearing with the principal or R 5113, page 9, designee if there is reason to believe an error in the attendance record or an extenuating circumstance exists. Before a student is denied credit or issued an order imposing administrative sanctions for failure to comply with the attendance requirements prescribed, the principal or designee shall provide written notice of the intended denial to the parent guardian of the student. The notice must include a statement indicating that the student and parent guardian may request a review of the absences of the student and a statement of the procedure for requesting such review. Upon the request for review by the parent guardian, the principal or designee shall review the reason for each absence of the student upon which the intended denial of credit is based. After the review, the principal or designee shall credit towards the required days of attendance each day of absence for which 1. There is evidence or written affirmation by the parent guardian of the student being physically or mentally unable to attend school on the day of the absence, and 2. The pupil has completed coursework requirements. If the parent guardian disagrees with the decision of the principal or designee that the standard under NRS 392.1223 and B has not been met, the parent may appeal to the assistant superintendent or designee. The assistant superintendent's or designee's decision is final. Attendance incentives and interventions. Incentive programs designed to promote and enforce the good attendance of students shall be developed and implemented at each school. Attendance incentive plans are to be developed with input from parents, students, and teachers and must be reviewed by each school's assistant chief or designee. Each incentive program will also include an intervention component. 1. The intervention component will be developed with the involvement of school personnel. 2. The interventions will be designed to address issues that affect students' regular attendance. R 5113, page 10, XI. This regulation is applicable to students participating in a program of special education or a Section 504 plan resulting from a student's disability, but subject to the student's individualized education plan or 504 plan and in accordance with the Individual with Disabilities Education Act. Legal references. Review responsibility, adopted, revised. Paul Governor Reverend, revised. NRS Chapter 392 Pupils NRS 483.2521 Instruction Unit 5113, July 12, 63, September 24, 81, February 11, 82, June 15, 89, October 14, 92, May 10, 94, September 10, 98, August 10th, 00, June 28th, 01, August 25th, 05, November 29th, 12, February 12th, 15.
So it doesn't look like this policy in regards to truancy has been revived since 2015. And it makes sense because it was 2014 that they had to move towards local control. And I don't believe they have any new policies that are adopted by governing board structure. Irregardless, it's important for parents to understand just how education was really not mentioned and the inability or the ability of a child was not mentioned in any of his documents. How children actually have the right to have full educational evaluations, and Clark County must demonstrate that the inability to transition to tasks is really what we're talking about. But to only base children's educational opportunities based on attendance is insanity because some children, just like people have attendance issues at work. I mean, it's just going to be reality. The school district has to be held accountable for the number of children who are making minimal progress towards the, grade level proficiency. And this is not what this document is all about. So this is why change has to come to Clark County and change has to come soon. I'm going to end this recording and I'll say, follow me. I'm on Anchor, I'm on Facebook, I'm on Instagram, I'm on Twitter, and I am on YouTube. Follow me. Educate yourself, empower yourself, and follow me on Anchor with the Parent Empowerment half an hour. But this is great information, and it's information that I didn't have to make up.